Dr. Phelan's talk. She is the author of several books. She's a true expert on museum law, nonprofit organization law and policy, nonprofit enterprises, corporations, trusts, and associations, and museums and the law. She's a member of the American Law Institute and a Texas commissioner to the Commission on Uniform State Laws, and a member of the Legal Affairs and Property Committee to the Executive Council of the International Council of Museums. She's a member of the American Institute of Certified Public Accountants and board certified in tax law by the Texas Board of Legal Specialization. She is also professor of museum science. She was given the Paul Whitfeld Horn Professorship at Texas Tech, which is the highest honor the university bestows on members of its faculty. She received the Grover E. Murray Award for Excellence in Higher Education in 2001 and received the President's Excellence in Teaching Award and the President's Academic Achievement Award for Excellence in Teaching, Research, and Service. She is Vice Chair of the Art and Cultural Property Law Committee of the Section on International Law and Practice of the American Bar Association, and she'll give us a history and analysis of laws protecting Native American cultures. Dr. Phelan.
Thank you for that introduction, and I want to thank Professor Judy Roster, Dean Levitt, and others at the University of Tulsa College of Law, and Dr. King and his staff at this beautiful museum for inviting me to speak here at this seminar. I also want to thank Barbette Veet for all of her help and hospitality. You've all been most kind. I think my discussion follows what Professor Riley was discussing in an international context. You should have a copy in your materials of a paper that I have prepared, a rough draft of a paper, that traces and analyzes the laws in the United States that are out there to protect and preserve Native American cultures. You might note on the first page of that paper the statement from Judge Cudahy in the Autocephalous Greek Orthodox Church case. In this 1990 case, the Seventh Court of Appeals ordered the return to the Republic of Cyprus 4 Byzantine mosaics that had been looted from a Greek Orthodox church during the Turkish invasion of Cyprus, which later had been sold in Switzerland through the illicit international art market. Justice Cudahy stated in that case that, quote, "The greed and callous disregard for the property, history, and culture of others cannot be countenanced by the world community, nor should it be sanctioned by the courts." Well, of course, Indian tribes in the United States have long thought that both the courts and the United States government have had a callous disregard for their cultures. As you know, countless Indian burial sites were desecrated in the past, and thousands of Native American human remains and funerary objects were sold or transferred and then exhibited in U.S. museums. Throughout the 20th century, Indian tribes lobbied Congress for recognition of their religious rights and for a congressional mandate that museums repatriate Native American human remains, funerary, and cultural objects in museum collections. The paper I prepared traces the tribe's ultimate success in obtaining congressional recognition and protection of their special cultures and religion. The first federal act that did provide some protection for Native American lands and ruins was the Antiquities Act of 1906 that's discussed beginning on page 7 of the paper. But as noted in the paper, this act has provided little or no consideration or protection for Native American ruins or culture. 60 years later, in 1966, Congress enacted the most important act still currently out there to protect our cultural heritage, and that is the National Historic Preservation Act, which brought about the National Register. But it was not until later, with amendments to this act in 1980, 1992, in 1994 that Native American cultures obtained some special protection. Under that act, the Secretary of the Interior now must work to foster communication and cooperation between Native tribes and state historic preservation officers to protect all types of historic properties. Tribes can designate a tribal preservation officer to administer a tribal historic preservation program. And properties of traditional, religious, and cultural importance to an Indian tribe may be included in the National Register. And further, pursuant to the National Environmental Protection Act, persons in charge of major projects funded in whole or in part with federal funds must consult with tribes that may be affected by a project. The effect of the project on Native American lands and culture must be considered and noted in the environmental impact statement. This then at least requires input from the tribes regarding projects that can have a negative impact on their culture. 12 years after enacting the National Historic Preservation Act and 72 years after the 1906 Antiquities Act, Congress recognized a need to protect and preserve the traditional religious rights of Native American tribes. So in 1978, it enacted the American Indian Religious Freedom Act. This act, however, has been a disappointment to Indian tribes, as courts have ruled that the act is merely a statement of a federal governmental policy to recognize separate religious beliefs of Native Americans, but of others as well. In addition, the Supreme Court ruled in 1988 in Ling versus Northwest Indian Center Protective Association, which is discussed on pages 18 and 19 of the paper, that the act does not provide for a private right of action for Indian tribes. Because there is no private right of action under the American Indian Religious Freedom Act, Indian tribes have attempted now to use the Religious Freedom Restoration Act to obtain protection of their sacred areas. However, in a recent 2008 case, Navajo Nation versus U.S. Forest Service, the Ninth Circuit Court of Appeal ruled that the Forest Service did not violate that act when it authorized a proposed use of recycled wastewater to make artificial snow for a commercial ski resort located in a national park on a mountain considered sacred by at least 13 tribes, the principals being the Hopi and the Navajo. The court further ruled that a final environmental impact statement prepared by the Forest Service satisfied the requirements of the National Environmental Protection Act and was substantively and procedurally accurate under the National Historic Preservation Act. The tribes contended that use of the snow on a sacred mountain contaminated the entire mountain and devalued their religious ceremonies. The mountains are the San Francisco Peaks in northern Arizona. The United States Supreme Court currently is deciding whether to hear this case, as the Indian tribes have filed a petition for certiorari. I did not discuss this case in the paper I prepared, nor the Religious Freedom Restoration Act generally, because I have not thought of that act as being on point directly to protect Native American cultures, but I will include it if the Supreme Court grants certiorari. And I did mention two recent cases that again considered whether the Bald and Golden Eagle Protection Act violates the American Indian Religious Freedom Act. In two 2008 cases, the tribes sought redress under the Religious Freedom Restoration Act. Both courts, the Ninth and 10th Circuit Courts of Appeals, have ruled that the act does not violate either the American Indian Religious Freedom Act nor the Religious Freedom Restoration Act. In 1986, the Supreme Court ruled in U.S. versus Dion that the Bald and Golden Eagle Protection Act abrogated a treaty with an Indian tribe that would have protected the tribe's rights to gather and hunt eagles for use in their religious ceremonies. The paper discusses on page 14 the current process now required for tribes to obtain eagle carcasses and parts from a depository in Commerce City, Colorado. This process is most offensive to many tribes. It often takes about 3 years to obtain a carcass, and in the process is accessible only to federally recognized tribes. The Ninth Circuit ruled in the 2008 case that the Religious Freedom Restoration Act does not require the government to expand its eagle collection and distribution practices. Another problem with the American Indian Religious Freedom Act is that it does not provide for repatriation of Native American human remains, funerary objects, and cultural artifacts in U.S. museums. Further, the 1906 Antiquities Act was early recognized as being too vague, and it did not provide protection for the tribes from persons who found and retained cultural objects on tribal lands. Thus, tribes continue to lobby Congress after the congressional enactment of the American Indian Religious Freedom Act for protection of their individual cultures, and principally for a return of their human remains and funerary and cultural objects that were being stored and are exhibited in U.S. museums. In 1979, a year after Congress enacted the American Indian Religious Freedom Act, it enacted the Archaeological Resources Protection Act to alleviate some of the problems in applying the 1906 Antiquities Act. As noted on page 8 and 9 of the paper, the 1906 Act did not find a ruin or object of antiquity and thus provided no protection for Indian tribes from persons excavating on their lands and taking religious objects of recent creation. The 1979 Act included a definition of an archaeological resource, and while it would not include religious objects such as face masks of recent origin, because the artifacts must be at least 100 years old, it does protect tribes by requiring that persons obtain a permit to excavate on Indian lands. And it provides substantially higher, steeper penalties for the illegal excavation on Indian lands than does the 1906 Antiquities Act. 11 years after Congress finally listened to the pleas of the tribes, in 1990 it enacted the North American Graves and Repatriation Act. This act followed the Supreme Court decision in Ling versus Northwest Indian Center Protective Association, wherein the Supreme Court ruled that a logging company could build a road through forest areas that Karak, Twalawa, and Yurok tribes use for religious rites and for the training of their spiritual practitioners. The court decided that because the government had taken numerous steps to minimize the immediate impact that construction of that road would have on the Indians' religious activities, such as choosing a route that best protected sites of specific rituals from adverse intrusions and planning steps to reduce the visual impact of the road on the surrounding country, that construction of the road would not burden unlawfully the Native Americans' exercise of religion. This case, decided in 1988, made Indian tribes realize they needed more protection. And in 1988, the Senate Select Committee on Indian Affairs held a hearing regarding legislation that would provide for repatriation of Native American remains. The panel was split on what to do about human remains that are not culturally identifiable, and this continues to be an issue. In that year, Congress enacted the National Museum of the American Indian Act that required the Smithsonian to repatriate human remains to cultural tribes, and of course created the National Museum of the American Indian. Then in 1990, Congress followed with the enactment of NAGPRA that became effective in 1991. A review committee established pursuant to NAGPRA monitors the inventory and identification process to determine identity and cultural affiliation of cultural items and the return of those items to the affiliated tribes. It facilitates disputes among tribes, federal agencies, and museums. And further, individuals now can be prosecuted for taking, selling, purchasing, etc. Native American cultural items obtained in violation of NAGPRA. As noted on page 22 of the paper, the most important case construing NAGPRA are the several court decisions in Bonishison versus United States that involved the Kennewick Man. A set of human remains believed to be over 9,000 years old were discovered in 1996 near Kennewick, Washington. While the U.S. Corps of Engineers transferred the remains to an Indian tribe for reburial, scientists who wanted to study the remains filed suit to prevent the reburial. The court finally determined that, quote, no reasonable person could conclude that the Kennewick Man is Native American under NAGPRA. No link was shown, either cultural or biological, between the remains and a tribe. So the question remains, from whence did the Kennewick Man originate? In the more recent case of Phelan Paiute Shoshone Tribe versus United States, discussed on page 24 of the paper, the court ruled that the Bureau of Land Management shut out the tribes out of the decision-making process in determining whether there was an affiliation with some remains that were nearly 10,000 years old that were found in the Spirit Cave near Phelan, Nevada. The court ruled that the BLM must consider fully and fairly the tribe's evidence and must have a reasoned discussion of the evidence and its reason for disbelieving or believing affiliation. The last part of the paper compares NAGPRA to the Unidwa Convention on Stolen or Illegally Exported Cultural Property, which was finalized in Rome in 1995. This convention provides for the repatriation of cultural property on an international scale. It also addresses claims for restitution of sacred and communally important cultural objects that belong to and are used by tribal or indigenous communities. The UNIDWA Convention reflects an international policy to protect the world's cultural properties and a general philosophy of the international community that unique remnants of earlier artistic periods belong to their homeland. It mandates the return of a stolen cultural object to the original owner or country. NAGPRA is based on this concept as it requires repatriation of cultural properties to affiliated tribes, the original owners. The UNIDWA Convention requires a possessor of a stolen cultural object to return it. It provides for a country to request a court or other competent authority to order the return of a cultural object illegally exported from the territory of the requesting country, and it states that the court or other competent authority must order the return of the illegally exported cultural object if the requesting country establishes that removal of the object from its territory significantly impairs the object's physical preservation, its integrity, the preservation of information of a scientific or historical character, or the traditional or ritual use of the object by a tribal or indigenous community. In a case cited on page 6 and 7 of my paper, the court ruled that a museum cannot obtain good title to Indian artifacts unless the museum acquired them from someone with authority of alienation, and that the museum must repatriate the artifacts unless it can show a right of possession. There is no time limitation for repatriation under NAGPRA. The UNIDWA Convention, on the other hand, does have time limitations. However, it has no time limitation for cultural objects forming an integral part of an identified monument or archaeological site or belonging to a public collection other than a 3-year limitation from the time the claimant knew the location of the cultural object and the identity of its possessor. The 1995 UNIDWA Convention provides a means to effectuate the principles of the 1970 UNESCO Convention on the means of prohibiting and preventing the illicit import, export, and transfer of ownership of cultural property. The American Association of Museums now has a new 2008 what it calls standards regarding archaeological material and ancient art, in which it recommends that museums have documentation to demonstrate that cultural objects in their collections were out of the probable country of modern discovery by November 17, 1970, the date on which the 1970 convention was signed. So progress continues. However, directors of major museums are continuing to assert that their museums have the right, and even as they contend, the obligation in what they call their duty to the public to collect artifacts from around the world. They now refer to the prior named universal museums as encyclopedic museums. They contend that they face constraints that have been placed on them by the archaeological community and by nationalist governments. They assert that the issue regarding cultural property really is political, that modern nation states claim culture for themselves, that they nationalize it. They contend these states' culture is important to nations' identity and that they try to police their culture. They have stated that art-rich nations put national borders around cultural property and claim it. They contend that encyclopedic museums must counter the nationalization of culture and its claim on antiquity. One proponent of this approach questions how one can accept that a cultural group has the character of a natural person and can be wounded by the loss of or damage to a national personal symbol, self-proclaimed, this individual states. But indeed, indigenous peoples do so contend, as well as do art-rich nations that have been plundered through colonialism and the illicit international trade in cultural property. Indigenous people, like these art-rich nations, feel that cultural heritage is important, is vital to the cultural sustainability of their tribes, to their cultural practices and identity. Can there, in the midst of these disagreements, continue to be negotiation, equal partnerships, and meaningful communication between tribes, the U.S. government, and museums? I think first the directors of these encyclopedic museums must recognize and respect cultural groups, countries, and peoples, to include indigenous communities that indeed are wounded when their cultural heritage is threatened or their cultural patrimony is lost. I recommend in the paper that the United States finally endorse and ratify the 1995 UNIDROIT Convention, that such ratification would make a statement to the world that the United States recognizes and respects the property, history, and culture of others, as it made such a statement in 1990 when it enacted NAGPRA 19 years ago. Still, tribes in the United States continue to have problems in convincing the courts that insensitivity to their religion still exists, but at least they are being heard, and the acts enumerated in the paper give them recognition. It's my hope that U.S. courts will continue, as many have in the past, to recognize the importance of Native Americans and other cultures, of their individual cultures, and will see the need for continued protection of their culture. For once a culture is destroyed, that people or that tribe also will cease to exist. Thank you for your attention.